Today we're celebrating the 200th anniversary of the first meeting of the Louisiana Supreme Court. The court as we know it was established in the Constitution of 1812 and had its first meeting on March 1st in 1813 at a building called the Government House, which is no longer in existence here in New Orleans. And it's a very significant day because our court has survived for 200 years. For 200 years we have been the final source for the resolution of disputes that people have in the state of Louisiana, and it's been the linchpin for the rule of law in the state of Louisiana.
Oh yay, oh yay, oh yay. The Honorable Supreme Court of the state of Louisiana is now in session. Order and silence are commanded under penalty of law. God save this state and this honorable court.
Welcome to the ceremony commemorating the 200th anniversary of the Louisiana Supreme Court. Would you please rise for the presentation of the colors? Our colors are being presented by the 1st of the 141st Field Artillery of New Orleans' own Washington Artillery.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Today we reflect on the 200th anniversary of Louisiana's highest court. Just as throughout last year we celebrated 200 years of Louisiana statehood. This court was created in Louisiana's first constitution, which actually was adopted in January of 1812 in order to petition the Congress for statehood, which was realized on April 30th, 1812. While any legal system must be predicated on rules of order and conduct as well as precedent, it is also a hallmark of the American system of justice that change is inevitable both in statutory and constitutional law, as well as interpretation by the judiciary. This was perhaps never more evident than yesterday at the investiture of Chief Justice Burnett Johnson, who took her oath beneath the statue of Edward Douglas White, Jr., a former justice of this court and the Chief Justice of the United States Supreme Court at the time of the centennial of this court. In a moment that history tells us was not his finest, then Justice White joined the majority in upholding the constitutionality of the separate but equal clause of Louisiana's Constitution of 1894. The case, of course, was Plessy v. Ferguson and arose from a simple train ride from New Orleans to Covington. This decision upheld de facto segregation and was a law of the land until overturned by Brown v. Board of Education. Years later, however, Chief Justice White wrote the court's unanimous decision in Gwynn v. United States, which invalidated grandfather clauses that disenfranchised blacks, finding these state statutes to be repugnant and therefore null and void. Yesterday's investiture certainly was a lesson in the life of the law. In 1913, during the centennial celebration of this court's creation, a verbatim transcript was made and published. Chief Justice White could not be present. He had a good excuse. He was swearing in the President of the United States. The Chief sent a letter which said in part, "I earnestly hope that this occasion may serve to refreshen the memory of every Louisianian concerning the blessings which have been bestowed upon the state by the faithful discharge by this court of the great duties which rest upon it. Indeed, I trust that the ceremonies may not only do this, but may serve to revivify and strengthen in the hearts and minds of all the purpose to sustain and perpetuate the court, and thus guarantee individual freedom and representative government by safeguarding the life, liberty, and happiness of all." Also speaking at the ceremony was Governor Luther Hall, who incidentally had been elected to the Supreme Court, but declined to serve, choosing instead to launch a successful career for governor, or campaign for governor. Governor Hall spoke eloquently. "A century is a short time in the history of a state as history goes. But on this side of the Atlantic, the swift tread of a free people has brought forth a record of great accomplishment and progress that has excited the wonder and admiration of the civilized world. The story of Louisiana, the pride of Spain, the hope of France, the glory of the American Republic, and the mother of great commonwealths will echo down the ages with ever-increasing interest." He went on to say, "When the people believe that their judges, in the determination of cases, consult the wishes of powerful political and other interests and not the law, when they believe that their laws are set aside or twisted and distorted by construction to subserve the purposes of such favored interests, and when they believe that all men are not equal before the law as administered by its courts, then all faith in the established form of government will have been lost and new and dangerous experiments will be attempted. Those comments followed opening remarks by Joseph W. Carroll, the president of the Louisiana State Bar Association and the Master of Ceremonies, who said, "The layman is prone to think and say that the courts generally are too far removed from the people and that judicial decisions do not respond readily enough to be advancing ideas of the people at large. They forget that courts are established to administer, not create the law. It is not for a court to be influenced by every passing sound, however loud or insistent." What has been loud and insistent during these past 200 years, and certainly the past 100 years, has been the independence of this court and its willingness to rise above the concerns expressed by the two speakers whom I have quoted. On behalf of the people of Louisiana, I say thank you and congratulations to those of you who now have the honor of serving, and thanks to those of you who have come before you. And now it is my pleasure to call upon the Chief Justice of the Louisiana Supreme Court for some welcoming remarks.
Exactly 100 years ago, at this very same time, in this very same building, the justices of the Louisiana Supreme Court assembled to celebrate the centenary of the Supreme Court of Louisiana. Presiding that day were Chief Justice Joseph A. Breaux and 4 associate justices, Justice Frank A. Monroe, Oliver Provosty, Alfred Land, and Walter Somerville. Louisiana Governor Luther E. Hall and New Orleans Mayor Martin Berman were also in attendance, and the courtroom was decorated much as it is today. Just as our brethren of yesteryear found it appropriate and fitting to mark the occasion of the first 100 years of the Louisiana Supreme Court in a significant manner, so too do we today find it appropriate and fitting to mark the occasion of the second 100 years of the Supreme Court in this special bicentennial ceremony. Joining me today in welcoming you are the sitting justices of the Louisiana Supreme Court: Justice Jeffrey Victory of Shreveport, Justice Jeanette Terrio Knoll of Marksville, Justice John Weimer of Thibodaux, Justice Greg Guidry of Jefferson and St. Tammany parishes, Justice Marcus Clark of Monroe, and our newest justice, Justice Jefferson Hughes of Denham Springs. We are also very honored to be joined on this historic occasion by several retired justices, including Chief Justice Kitty Kimball, Chief Justice Pascal Calagero, Justice Jim Dennis, Justice Harry Lemon, and Justice Chet Traylor. The ceremony today captures the history of the Louisiana Supreme Court. If we could have those committee members stand to be recognized at this time. Thank you for your hard work this year on this project. We're pleased to have several distinguished speakers today, and I thank them for their participation. I also want to mention that the April-May issue of the Louisiana Bar Journal will include articles relevant to the history of the court by authors who are not speaking today, and I would like to thank them for their contribution to the upcoming Bar Journal. Chief Judge Gene Thibodaux from the Third Circuit will have an article. I don't know if he's here present today. Professor Oliver Merito from UNO, Professor Paul Baer, and Mr. Phelps Gay. So we ask you to wait and look forward to that Bar Journal article on this event. We will be publishing a commemorative booklet after today's ceremonies, and if you will complete a form that we have available, we'll send you a copy of that booklet. We've created also a bicentennial web page on the court's website. Today, as we celebrate 200 years of history, I'm pleased that we have young people participating in this program. We have a very impressive group of students from the International School who will be performing a skit on the birth of Louisiana, some very talented students from Lusher School. The jazz combo will be entertaining during the reception, and so we are just really pleased, extremely pleased to have young people involved in this program today. Several months ago, in commemoration of the court's bicentennial, we held oral arguments, as I said, at the Cabildo, where the Louisiana Supreme Court was housed from 1853 to 1910. We held court in the Sala Capitular, the original room where oral arguments were held. The first home of the Louisiana Supreme Court no longer exists, but we have the very next best thing, a model for you to view. On your way into the courtroom this morning, you may have noticed the model of the government house of the French colony of Louisiana, home of the French Superior Consul. The government house was built in 1761 and was located not far from here at Toulouse and Decatur Streets here in the French Quarter, about 200 feet from the Mississippi River. After statehood, the government house was occupied by the Louisiana legislature and then became the Louisiana state capitol until it burned in 1828. The Louisiana Supreme Court first convened at Government House on March 1, 1813, 200 years ago today. And we have Lieutenant Governor Jay Dawton to thank for having that model here today. It's on loan from the Louisiana State Museum. Again, thank you and welcome. We appreciate every one of you for being here today to share and to mark this historic occasion with us. And I'll turn the program back over to Lieutenant Governor.
Our first speaker today is Professor Richard Campanella. Six-time author Richard Campanella is a senior professor of practice at Tulane School of Architecture. In addition to his award-winning works, Professor Campanella has been honored with the Williams Prize for Louisiana History and Tulane's Mortar Board Award for Excellence in Teaching. Professor Campanella will take us on a walk through the streets of New Orleans at the time of the court's foundation. Professor?
Thank you. It's an honor to be here. I'd like to take you back to the era of the court's foundation, focusing in on the 1810s, 20s, and 30s. 200 years ago, Westerners pressed their political representatives for what Americans at the time called internal improvements, that is, transportation infrastructure. New Orleanians did the same locally. First on their priority list was the main riverfront port and wharf, a plank-covered platform 40 yards wide, thousands long, and open to the sky. To its scores of docks moored, quote, the most extraordinary medley of craft ever possible, a variety, unquote, including ships, brigs, schooners, sloops, barges, keelboats, flatboats, steamboats, steam ferries, and steam tugs. The great fleet fronted sundry cargo and ant-like, quote, bustle and confusion, circulating upon the spacious landing, which was in constant need of repair, expansion, and upgrading. By one estimate, New Orleans riverfront, quote, rated as the fourth port and point of commerce in the world, exceeded only by London, Liverpool, and New York. By another, it represented, quote, the leading export city of the United States and one of the leading ports of the world, unquote. It employed thousands of New Orleanians and brought outside currency into local coffers in vast quantities. A second target for internal improvement vied to connect New Orleans with its hindquarters, Lake Pontchartrain. Firewood, lumber, pitch, tar, fish, and fowl generally came from the marshes and piney woods in and around Lake Pontchartrain. French colonials had used Bayou St. John and Bayou Road to access these lake resources since 1718. Spanish colonials superseded that route by excavating the Carondelet Canal in 1794. This is present-day Lafitte Street corridor. Demands on the growing population in the American era motivated Creole businessmen in the lower city to solve the lake access problem with an exciting new technology, railroads. They formed a company in 1820 won a state charter the next year, laid 5 miles of track along Elysian Fields Avenue, and inaugurated the Pontchartrain Railroad in 1831, the first one west of the Appalachians. Its success piqued the interest of uptown Anglo businessmen who envisioned a superior artery for their district. And in 1831, the New Orleans Canal and Banking Company invested $4 million to build a 60-foot wide waterway and toll road connecting Faubourg St. Mary with Lake Pontchartrain. This is the present-day I-10 corridor between roughly the Superdome and the cemeteries. Completed in 1838, the New Basin Canal, distinguished from the Carondelet or the Old Basin, succeeded commercially, bringing into the American quarter a steady stream of sand, gravel, and shell for fill, lumber, firewood, and charcoal, fruit, vegetables, cotton, and seafood, and other cargo from the lake and Gulf. The typical New Orleanian purchased goods shipped on these arteries on a daily basis. All three would survive well into the 20th century. A concurrent improvement brought passenger railroads to city streets. In 1833, uptown investors aiming to create valuable real estate in the upper banlieue, what we now call uptown, won a charter for the city's second railroad. Gaining access to a 120-foot wide easement along multiple sugarcane plantations, they laid 4.5 miles of track along Naiad Street, present-day St. Charles Avenue, to the Jefferson Parish town of Carrollton. The New Orleans and Carrollton Railroad commenced full scheduled service in September 1835. With this trunk line in place, New Orleans would, over the next 90 years, develop a vast and intricate urban streetcar system, including a line right here on Royal past this courthouse. I started off the program talking about what it was like to walk around the streets of New Orleans at the time of the court founding. The time of the court's foundation, the population had just doubled 4 years prior. Transportation infrastructure was a huge concern. Streets were muddy, conditions were rough, and the ethnic landscape was intricately mixed.
Thank you, Professor. Our next speaker is Professor John Randall Trahan. Professor Trahan, the Louis B. Portery Professor at the LSU Law School, received his Juris Doctor with high honors from LSU, joining the faculty there in 1995. He is widely considered an expert in the area of civil law systems. As a member of the Persons Committee of the Louisiana State Law Institute, Professor Trahan actively participates in law reform work. He will discuss the civilian aspects of Louisiana law.
Bonjour, messieurs et mesdames. Someone had to speak French. It might as well be the Cajun presenter. Thank you, Lieutenant Governor Darden, Chief Justice, Justices of the Court, especially you, Justice Guidry, for inviting me to be here with you today. As you can see from your program, and as the Lieutenant Governor himself just said, my talk to you today has been billed as the civilian aspects of Louisiana law. But I've made that presentation before, and that was on the occasion of the bicentennial of the founding of the federal court, to which Judge Lemon had invited me. It seemed to me then that on this occasion, it might be wise for me to go ahead and tailor my remarks to the occasion that has brought us together, and that, of course, is to celebrate the bicentennial of the founding of the Louisiana Supreme Court. So instead of talking to you about the civilian aspects of Louisiana law in general, what I propose to talk to you about today is instead the role of the Louisiana Supreme Court in preserving and developing the civil law tradition in Louisiana. Way back in 1813, when it was perhaps even more difficult to get from Baton Rouge to New Orleans than it was for me to do so today, and when this court was first founded, the justices faced a singular challenge, singular in the sense that their counterparts, that is, justices on other newly formed state courts elsewhere in the fledgling United States, didn't have to worry about anything like it. Well, what was that challenge? It was to work within two very different legal traditions. Now, those traditions are common law and the civil law. The first, common law, what is also known as the Anglo-American legal tradition, well, that's the one that every newly formed state Supreme Court had to deal with, whether it's here in Louisiana or over in Mississippi, for example. But the second, the civil law tradition, or sometimes called the civilian tradition, the continental tradition, that's the one that was the unique concern of the Louisiana Supreme Court. Not only were these traditions different in terms of the content of the rules that were a part of them, but they were also different in terms of the legal vocabulary, in terms of which the rules were cast. They were different in terms of the methodologies through which the law came to be created in the first place, through which it was later interpreted and applied. They differed in terms of their sources, and finally, they differed in terms of the languages, about which I'll have more to say in a minute if I don't forget about it along the way. Well, the challenge then is for this court to work in both traditions. Now, let me be clear. I'm not saying work in both traditions at the same time in the sense of having to draw on both traditions to solve a single case. That's not true. These two legal traditions, in terms of their sphere of application, were pretty well delineated and separated off from each other. The Anglo-American tradition, the new Louisiana Supreme Court, had to apply to what we call the public law, that is the part of the law that governs relations between the government and individuals. For example, criminal law, what we would now call constitutional law, tax law, and so forth. The civil law, on the other hand, that tradition was to be applied to what we now call the private law, and that's the part of the law that regulates relations between private individuals or between the government when it's acting as a private individual and individuals. Now, at the time of the founding of the Louisiana Supreme Court, just in terms of the size of the law, the private law was much more vast than the public law. It included the law of family, the law of contract, the law of tort, personal injury type law, the law of inheritance, the law of property, and even the commercial law. So it's a vast field. It sort of eclipsed in terms of its size the field that was covered by this Anglo-American law. Well, my bicentennial message to the Supreme Court concerned the historical role of the Supreme Court in preserving and developing Louisiana's unique legal tradition, that is, the civil law tradition.
Thank you, Professor. Now, if you will allow me one brief postscript to those very interesting remarks, it's not surprising of what the professors described was symptomatic of what was happening in Louisiana in the early 1800s when the decision was made whether or not Louisiana would become a state. After the Louisiana Purchase, it was expected that all the territories would eventually become states, but there was a lot of rancor and a lot of disagreement in the halls of the United States Congress as to whether or not that would happen. They looked at Louisiana and we were different. We're different then, we're different now. Louisiana was multicolored. People had different skin hues. They spoke different languages, French and Spanish. They were predominantly Catholic. Everyone on the eastern seaboard, members of the United States Congress, looked at Louisiana and said, we just got rid of our allegiance with Europe. Why would we want to reinstitute it by allowing Louisiana to become a state? But fortunately they did, and the issues you've discussed are very symptomatic of that time, and the fact that this side of Canal Street, occupied by French and Spanish and Creoles and free people of color, was distinct from the other side of Canal Street, now known as the American sector, because that's where the Americans, the new kids on the block, the minority, white Anglo-Saxon Protestants who came from what was America, came to Louisiana. And so that's what makes our history so rich and our culture so rich, and the law is certainly a symptom, or really is a reflection, rather, of who we were as a people. We were that way then, and we're to some extent still that way now. Professor Raphael Casimir joined the UNO history faculty in 1971, retiring as a Serafia D. Leda University teaching professor emeritus in 2007. Highlighting Professor Casimir's civically active career is his being awarded the A.P. Turo Black Citizenship Medal, the highest award conferred by the NAACP in the state. Professor Casimir is the author of African Americans in New Orleans Before the Civil War. Professor Casimir will speak on the role of the Louisiana Supreme Court in the early civil rights movement.
Good morning, or bonjour. A voteless people is a hopeless people was the slogan of Louisiana Weekly for many years. It aptly described the condition of African Americans in Louisiana. For much of their history, black Louisianans were denied the basic right to vote, which made them an impotent political constituency, treated more like wards rather than citizens of the state. They could not hold accountable their public officials, and there ensued a long and bitter struggle for civil and political rights that spans the state's history. Prior to the Civil War, because no African American in Louisiana could vote, no public official responded to their cries for equal justice. A study of the role of this court, the Louisiana Supreme Court, in the early civil rights movement showed that it was largely negative. For much of its history, this court was at best indifferent and at worst hostile to the interests of people of color. Its earliest decisions made clear that the state government was created by and for white people. To be sure, however, these views were consistent with those of other courts, including the National Supreme Court. For example, in 1857, in the Dred Scott case, the United States Supreme Court similarly ruled that no black person, free or unfree, was a citizen of the United States, and blacks had no rights which whites were bound to respect. Not surprisingly then, 2 years later, in one of its earliest decisions defining the state as a black people, the Louisiana High Court ruled the African race are strangers to our Constitution, and they are subject of special, exceptional legislation. But during a brief period of Reconstruction, the court's views changed somewhat, perhaps in part because African Americans had gained the right to vote. Black office holders helped to write a new colorblind constitution and pass anti-discrimination laws. Subsequently, the state high court ruled that black citizens were now entitled to the equal protection of the law as guaranteed by both the 14th Amendment and the state's new constitution. Specifically, the Louisiana Supreme Court upheld a district court ruling in Hall versus DeQueer, which ruled that common carriers such as railroads and steamboats could not refuse admission to or expel anyone from their conveyances. But this victory was short-lived, because only a few years later the federal Supreme Court reversed the ruling and overturned Louisiana's anti-discrimination law, supposedly because it intruded Congress's plenary power to regulate interstate commerce. The ruling in Hall versus DeQueer was the last time, for a long time, that the state's high court ruled that black citizens were entitled to the same rights as whites. Thereafter, the state followed the lead of the United States Supreme Court. About a decade after the Hall case, the state Supreme Court sustained Judge John Ferguson's ruling that the state's newly enacted Separate Core Act neither violated the state or federal constitution because it provided for separate but also equal accommodations for the races. In reality, however, public facilities for the two races were always separate, rarely equal, and in many instances non-existent for black citizens. Additionally, at the end of the 19th century, the state eliminated practically all of the black electorate and sent African Americans on a downward political spiral, which assured that this impotent constituency would continue to be eagerly ignored.